This episode of Southeast Iowa Today is brought to you by Griner Auto Body of Washington, Iowa, using state-of-the-art techniques and decades of experience to get your car back on the road after an accident. Car Doctor of Washington, Iowa. No matter who Frankensteined it, they can fix it, clean it, and customize it. McDonald Boatyard of Keota, Iowa, for all your farm equipment and auto recycling needs. For great food, it's your choice family restaurant of Wayland, Iowa. Open Tuesday through Sunday. Try the John Bain sandwich on your next visit. Girling Repair of Winfield, Iowa. If your mower is dead, call Fred, your Husqvarna, Aaron's, and Gravely dealer. Fred also fixes and sells snowblowers. B&B Propane and the family of jet stops. CW Tree Trimming, LLC. We're into your trees, not your wallet. Serving all of Henry County and the surrounding area, and we offer a senior citizen and veteran discount. Dutch Market and Coffee Talk of Washington, Iowa. Dutch Market can handle all of your grocery needs. They even have a conference room that you can use for free. Coffee Talk's drive-thru is open and ready to serve you coffee, energy drinks, sandwiches, baked goods, and ice cream. They all present the award-winning Southeast Iowa Today. Here's the author of Christie's Journey, The Beat Goes On, and your host, John Bain.
Thank you, announcer Cody Roy of NewEnglandDukes.com for your golden pipes and wonderful introduction. On this episode, I share with you the video content of the Jefferson County Board of Supervisors meeting with attorney at Smith Mills Law, Skyler Limkemann, to discuss and consider attorney representation contract. I did not attend this meeting on Monday, September 29, 2025, because I was podcasting from Indiana that day, and I will share with you soon 2 very cool episodes. Thankfully, the Fairfield Media Center YouTube channel had this meeting uploaded, and that right there, folks, is how you credit your source material. Why can't local newspapers do that every time? That's a rhetorical question. As I was watching this meeting, I took a lot of notes to be ready for this introduction, and I crumpled them up and threw those aside while shaking my head. Here's that meeting.
All right, so I'm going to call this meeting to order, and I don't know who to open it up to, I guess.
Go ahead. Listen.
Okay, well, I guess if it's all right with everybody, because Skyler, I apologize, I have a terrible time pronouncing your last name. So I'm just going to open it up to you. You have some concerns about paragraph 2 on page 2.
Yes, sir. Thank you. And it's fine to call me Skyler. The Limkemann is always a hard name to pronounce. So I get that all the time. So Skyler is just fine. Well, first and foremost, thank you for having this meeting this morning to discuss the representation agreement. I know that we've had a couple prior meetings and I was not able to be at the one last Wednesday because I was out of town for other matters. I just want to start off by just noting a little background about myself. I do these cases all over the state of Iowa. I've done them for employees, employers, civil service commissions.
Excuse me, Lee, I cannot hear very well.
Okay. Skyler, can we turn that volume up any? Hang on a second.
Thank you.
Let's see how that works. Okay.
Is that better?
Thank you.
Can you hear it now?
Yes.
Okay.
I handle these cases all over the state of Iowa. I've done a number of these for other counties. I've done quite a few of these in a variety of contexts under the new and the old statute. So I would say I'm pretty experienced in this area. I also do quite a bit of work for ICAP in defending these cases and handle a lot of different municipality cases. And I know we've previously represented the county and the sheriff's office and other county officials in other matters. So I just wanted to provide that little bit of background. I'll get right to the representation agreement. I did listen in on a prior board meeting, and this representation agreement is very limited. It's limited to 2 employment investigations that are covered by the Peace Officer Bill of Rights, which is Iowa Code Chapter 80F or Section 80F.1. This representation agreement is very clear that it does not include any appeals, litigation, or anything like that. That would be something that if, an employee that is covered by the Peace Officer Bill of Rights, if there's an investigation, they're found to violate policy, and they're disciplined and they disagree with that discipline, for example, a deputy sheriff, they could appeal that to the Civil Service Commission. So the appeal to a Civil Service Commission or anything beyond that would not be covered by this representation agreement. We are strictly dealing with the investigations, the pre-discipline process there. So I wanted to make that very clear. The paragraph on page 1 that was inserted by the county attorney's office, I don't necessarily have a problem with that because I really don't see that scenario coming up. But for me, that really doesn't concern anything with my representation in this case, because it largely concerns, the event of either appeal, litigation, things like that would be triggered down the road because the county attorney has a statutory duty if there's an appeal to civil service to represent the Civil Service Commission. So no issue there. The first paragraph there where it strikes out the sheriff's office where it says attorney-client privilege and confidentiality. I went back and I looked at not only the ethical rules and the Iowa Code Section 622.10 and some case law on attorney-client privilege, and then looked at the applicable confidentiality section under 80F.1 subsection 20. And I think that for the purposes of this investigation, this very limited scope representation here, that the county is essentially seeking independent counsel under the statute for these employment investigations. And in doing that, the county is paying the bill. They would be retaining our services, right? But the decider on these issues is the office of the sheriff or the sheriff's office, not Sheriff Richmond, Bart Richmond in his personal capacity, but he is the commanding officer of the sheriff's office. Those are officers under the meaning of the statute that are employed. They're within that office, so he is the decider in that case. And so when we look at that, I believe that privilege and confidentiality does exist for these limited purposes with the sheriff's office. And I'll explain that a little bit further. Ultimately, what I'm asking for is on page 2, and I'll just pull that up here. Page 2, the top of page 2, the inserted paragraph that starts with, the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, so on and so forth. And then it ends with, the firm will also copy the county attorney on any communication between the firm and the client or its officers. I'm asking that paragraph be deleted out from the agreement, and here's why. So the first reason, it was my understanding that I was being sought for independent legal counsel, and it was my understanding that basically that was being done to separate the county attorney's office out from these investigations and the pre-discipline process and provide independent counsel in coordination with John Thomas from Workforce Solutions as an independent investigator. Obviously, the sheriff's office could do the investigation, but they'd opted to ask for an independent investigator, which you guys hired. And so I think that's a great idea. It's a great practice to do that in these types of situations. But by that language, it seems like the county attorney's office isn't out of it, and then it seems to run contrary to the independent process that we've talked about here. And so I guess the question would become, is the county attorney's office, is it out of these matters unless they would become appealed or litigated? Because that was my prior understanding. So because of the statute, excuse me, if the employee would appeal it, then by statute, the county attorney's office would have to represent the Civil Service Commission when we back in. Obviously, I would be out of at that point because you guys would submit the claim to ICAP, is my understanding from the chairman. And so I wouldn't have anything to do with that. I would just be doing the investigation and pre-discipline process piece. So I guess for the independent counsel, the question really becomes, is the county attorney's office in or are they out for the purposes of the investigation and the pre-discipline process? Going back to the attorney-client privilege issue, I have a concern about that because I see all the time, representing municipalities, that people try to pierce attorney-client privilege and get access to information that they probably shouldn't have, right? The sheriff, obviously, is a county official. You are the board, so you are the county as a legal matter. You guys are viewed as the same thing. It's viewed as Jefferson County. But the county board, under the statute, is hiring outside counsel for the sheriff's office and is paying the bill in that situation. The county, as in the board, is not otherwise involved in the matter because it's the sheriff that's ultimately going to decide what comes about from these investigations, whether he agrees with the investigation, whether he doesn't, and if there's any discipline to be imposed, what that is, what that should be, so on and so forth. So that's where I come back to, for the purposes of this limited representation agreement, the sheriff's office, literally the office of the sheriff, is the client. And I think, in really thinking about what my phone call with Mr. Molding last week, and then looking at everything and thinking about this further, I need to be able, as independent counsel, to communicate with the sheriff regarding these matters, and he needs to be able to independently, openly communicate with me. That's the whole point of being independent from the county attorney's office, at least as I see it or understood it. Now, I understand that there's a lot of disagreement, dispute. There's prior pending litigation between the sheriff and the county attorney's office. I've told both of them I want no part of any of that. I do not want to be in the middle of that. I do not want to be in any way, shape, or form involved in that. So having me independent and removed from that mitigates any issues of getting crosswise or anything, whether it's a perception, whether it happens or not. It just keeps everything clean. And then we're not having other issues. Again, I also have concerns about, whether attorney-client privilege in those situations would be waived. I don't know the answer to that question because, frankly, as I think you folks know, some of the things that you're dealing with are questions of first impression. There's not an Iowa Supreme Court opinion on these things because they've not been litigated. But I certainly don't want to be the first one to try and then end up in years of litigation or, and I certainly don't want you to be in that position and spending, a lot of money trying to sort these questions out. So that was part of my reasoning on the attorney-client privilege issue, is keeping it clean. And then the third point was the confidentiality of the information. The law requires the information, the sheriff's office, to keep the information confidential. So that's the complaint, the statements, things like that. There have been some reported court cases where, let's say that a city, they include in the report things that the employee said in the investigation interview or in a pre-discipline hearing. Well, that was determined and said to be an improper violation of the confidentiality piece because they disclosed that information in these cases. And there's other cases pending on that right now. So my thought process is on the independent counsel point is keeping it within the people that only need to know for those purposes. And right now, the only person that I see that would need to know would be obviously John Thomas as the investigator, the sheriff, as the commanding officer of the sheriff's office, and then me. And that would keep that, obviously the employees too, and their legal counsel, but that would keep that information confidential. I don't believe that legally I could or the sheriff could share information that falls under that code section with you as the board, or anybody else for that matter. Now, I think that there's things that could change that, right? If an employee appeals it, that appeal proceeding is a public proceeding and things could come out in that appeal proceeding. But we're not talking about that because my representation agreement does not include any appeals or litigation. So all those things that were talked about previously are not things that involve me. Those are things that would happen down the road if they happen at all. I'm hopeful that we get these matters resolved and that there wouldn't be, any appeals or litigation. But as you know, and as Mr. Lee, is it DeMint?
Yes.
Hopefully I pronounced that correctly. As you indicated, everybody sues everybody these days. And I look at things the exact same way. I'm a city councilman myself, and I just always assume that we're going to get sued, And so I'm looking at it from that perspective of what arguments could somebody have if they wanted to try to come at this down the road? Because the whole goal is to keep you from that occurring in the future. And then the last point about the confidentiality, that's the officer's right. And I'm saying officer because it's defined under the statute, but we need to make sure that that law is followed. And I just don't feel comfortable with not having this exact scenario and without having a Iowa Supreme Court opinion or Court of Appeals opinion on point. I just don't feel comfortable going down that road because I think it opens everything up for some future argument. Maybe that doesn't happen. Maybe I could be wrong, but I have to be cautious with these things because if I didn't, you would say, Skyler, why didn't you say that ahead of time? And I definitely don't want that. Again, there's no litigation or appeal right now. We're just in the investigation phase. So we don't really need to know either, but we have to think about that. And then I know that the sheriff addressed some of the benefits of independent counsel 2 meetings ago when this was discussed, when you originally voted. I see it as a way of protecting all involved, mitigating risk, keeping things clean. And I know that things can get messy really easy, but by just saying Skyler's handling the investigations for these 2 matters and the pre-discipline process independently, that keeps everything really clean in my view. I do these agreements across the state. I've done a lot of different places, employees, employers, municipalities, all that. I've done them with the state. I've not seen any similar language, elsewhere. I'm not saying it doesn't exist, but it's not something that's typically in our representation agreements. And again, I just don't want to end up in any, disputes, disagreements. I do not want to be in the middle of anything. I want to come in, handle these 2 employment investigations, deal with the pre-discipline process, advise the sheriff, let him make his decisions, and then my part would be done, absent something else, that I'm missing there under the agreement. And then I would be out of it. So if they appeal, then that would be ICAP. If you choose to do that, I would be done. Or if the meter stops running at $5,000, like you indicated previously, I'd be done. I hope it doesn't cost that much, but you never know what people are going to do. And there's videos and, a lot of different evidence to look at here. And at the end of the day, I just don't, even if take all the other stuff, push that aside, I just don't feel comfortable with that language in paragraph 2 being in there. It just really puts me in a difficult position that I just frankly don't want to be in. And I understand that, you guys, somebody had indicated at one of your prior meetings about being in the middle. I certainly appreciate that and understand that. I certainly don't want to be in the middle either. I want to do my job and then, be done with this. So that's where I'm coming from. That's why I'm asking that be removed. And I'm happy to answer any questions from any of you fine folks.
I do have a couple, not so, they're kind of generic, I guess you'd say. So where my concern comes in is in the event that it moves beyond your role, and it does go to the next level where there's an appeal filed or lawsuit or whatever. My thinking behind this and agreeing to insert that paragraph, if we don't have something that says we get this stuff, not legal terms, obviously, then can we access it in a lawsuit if we're sued?
So litigation is different. So there's actually a case called Dunn v. Doe's. It was out of the Southern District of Iowa. It was a Des Moines case. And what the Southern District of Iowa ruled was, and there's been other court rulings on this too, that confidentiality protection that I referred to under subsection 20 does not apply to discovery or litigation. So somebody could subpoena it, for example, somebody could get it in discovery, and if there is litigation, and something's going to go to trial, you can't, like, if you get into a car accident and you're claiming that you were injured, and you have medical records, you can't keep your medical history out of a public trial or from discovery. It's the exact same thing. That would be crazy. That applies here too. So to answer your question, that litigation or an appeal would change that. And that's why I don't think that paragraph belongs there, because right now we are not at that point, and my representation agreement does not cover appeals or litigation. So you guys would get that, and the public would have access to that information if at some point in time in the future it became a public hearing, an appeal, or whatever.
Skyler, I gotta jump in here. Are you talking about the county being entitled to its own investigative records if we're sued through a discovery process? Like we would subpoena our own records?
No, I'm just saying that if somebody else wanted those records, that's the only way that they would be able to get them. Like a third party, somebody couldn't do an open records request for the records and get those under the statute.
Someone adverse to the county.
Correct.
What happens, can I raise a question? What would happen if you're only signed on for 20 hours or $90 an hour for your assistant, legal assistant? What would happen if the county's $5,000 is expended only halfway through this? And in the county attorney's office, we're responsible legally under the law to handle this matter. The sheriff clearly has the authority to do the investigation himself or to refer it to counsel, as is being done in this case. But we need some way for the county, as the county's lawyer, to know what's going on and what's happening. We want to stay informed just so that we can know where the case is. If we have to step in, it makes no sense for it to all, where we have to try and discover what's been happening. It's very important that this matter be resolved as soon as we can. The people are being paid their full pay during all the time since this originally started. We want to see it proceed as soon as possible for economy for the county. And it seems important that we know what's happening in the county's legal interests.
So there's multiple things there. One, the $5,000, I would hope that it would not go beyond that. Generally speaking, I mean, there are 2 cases involved here. That was my kind of concern before. I mean, I do officer-involved shootings all over the state, and they don't usually ever exceed $10,000. Usually they're between 5 and 10. I don't think that would happen here, where we would have a situation where the 5,000 would be exceeded. But if there was some situation, I would just come back to the board and say, this is the situation that came up. You guys can vote on it. I would most likely say that we would get this thing done in short order for $5,000 or under, because what we're dealing with is the investigation piece and the pre-discipline hearings. So public employees, if they're going to be disciplined, have a constitutional right to a pre-discipline hearing. That's the Loudermill case. And so, what we're talking about is, a limited amount of work. If that happens, though, we were getting close, I would circle back. I just don't foresee that coming up at this point. I can't guarantee, though, what's going to happen with any employees or anything, but, that's where I'm at right now with it. I mean, that'd be 20 hours worth of work. Generally pre-discipline hearings are an hour, I mean, that's on average. I've had them go up to 3 hours. So you have 2 employees and there's 2 hours right there, so I just don't see that coming up. On the part about being informed, so I went back and reread the statute 331.756, duties of the county attorney, and as I read the code, there has to be a pending, case, whether it's litigation, because it says in all cases and proceedings in the courts of the county to which the state or the county is a party. So I don't think that applies here, because if, for example, the sheriff's office just wanted to do this on their own without legal counsel, they would not have to involve the county attorney's office. And because of the confidentiality piece, I don't believe that the county attorney on its own would be able to, be involved in something prior to discipline. And this is an open question, mind you. The situation that you are dealing with has not came up, to my knowledge, before, and there's no reported court cases on it. So I'm saying this with a caveat that, a judge or, the Iowa Supreme Court could do whatever they wanted if that case came up. I don't think that that's gonna happen. I would hope that there's no appeals or no litigation, but again, I can't guarantee what somebody's going to do. And I certainly appreciate the county attorney's position in talking to him about wanting to be informed, on things that are going on. But in this particular situation, during the investigation and the pre-discipline process, I just don't see a way. I don't see a way for that to happen, because it defeats the whole purpose of independent counsel. The board can say, for this matter, for the investigation, the pre-discipline process, Skyler's handling that. If it goes to anything beyond that, obviously then by statute, if it's a civil service appeal, the county attorney is involved and they would get the information during that process. But particularly the emails, communications or whatever, for example, if I'm on the phone with the county attorney, if I'm on the phone with the sheriff, is the county attorney going to want to be on the phone too to discuss, strategy, tactics, what's going on, recommendations, advice, things like that? Because I believe that the whole issue that I don't want to be involved in is there's a pending matter between the county attorney and the sheriff. And that was kind of part of the reason why the sheriff was asking that this be separated. I'll let him speak for himself. Again, though, I do not want to be involved in that. I do not want to touch it with a 10-foot pole. That's why I think being independent is easiest for everybody.
And I would concur with that. The completely separate matters. The one thing has nothing to do with the other. And I don't know that's why Skyler was brought on board here, but I guess, yeah, the sheriff can speak to that. Completely separate issues and improper to even consider one and the other at the same time.
So to go back to my just for my own, and I apologize for being ignorant on these matters, but my overriding concern, to be quite honest, is that if it came to litigation, I guess what I want to know is somebody to tell me, whether it's Skyler, whether it's Chauncey, and it doesn't matter, somebody to tell me that when it comes to litigation, all the pertinent information that might be considered confidential is available for us to defend ourselves in that litigation.
100%. Absolutely.
And I think that's what kind of, there's some crossing of maybe communication lines getting crossed here, Lee. There's one team here, and that's Team County. The contract hires Skyler's firm to represent the county in what is a relatively straightforward, or I guess technically two straightforward employment issues. I think Skyler's right. I think the sheriff could have handled this on his own. I certainly, I think it was appropriate to hire outside investigator to look into these facts. But yeah, there is no statutory obligation that we go outside for this. But honestly, I'm shocked that we're still here, that we're still having these conversations. It's almost 2 months have passed since this incident. This could have been addressed a month ago or longer. But I think it's important to emphasize, you're right, Lee. The client here is the county. The county is hiring Skyler's firm, who has a strong background in ADF litigation and ADF issues. I think you're one of the state's leading, you have substantial knowledge about the statute. And us hiring an outside expert to assist with this, I was opposed to it. I think it was an enormous waste of taxpayer funds, but it's where we are. But that's who we hired. We hired Skyler, we being the county, in order to protect the county's interest here. And I do have some concerns when Skyler's saying the issue is, I feel like communications about this case between myself and the sheriff, I'm putting words in your mouth, sir, but words between you and the sheriff might not be open if there was sharing of that information with the other legal representative for the county. I don't understand why that would be, and it does raise more questions than it answers for me, because again, the goal here is to protect the county. The county has to take an action, and doing so with appropriate legal representation is always a good idea. But if we're venturing into the realm of the employing officer has personal concerns over other individuals reading the deliberations or considerations of the employment decision, we're way outside of the scope here. The scope here is protecting the county during a determination of appropriate discipline. And if the real concern is protecting the considerations, that's just not where we are. So it's just confusing and a little bit concerning that the major question that I think Skyler has is whether or not the other legal representative for the county, the only one with statutory duties to protect the county attorney's office, should be looped in. If this was a Fortune 500 company hiring outside counsel to conduct an internal audit of their practices, it would be not only expected and normal, but completely de rigueur and regular process to loop in corporate counsel during the scope of the investigation. That's a completely normal process. The confidentiality exists more between my office, the board, and the sheriff than it does with any outside counsel. So if the concerns are the statutory confidentialities in ADF, that exists already. So I don't know. That's the main concern I have with this whole deliberative process. Is there's nothing to hide. And if Skyler, or anybody else is concerned about protecting confidentiality of information, what is being protected? The county should know what's going on inside the county, right? So that's my major concern with the fear over looping us in on deliberations. What do you got to hide, I guess, is the major question that raises for me. So
We are all sworn to protect the confidentiality of our clients. County Attorney Molding and the assistant county attorneys are all sworn to confidentiality. We want to make this be the best result possible for the county, but we just want to know what is happening, just to be copied on the information so that we can follow it while it goes along. It's not gonna blow up, and only in a small percentage of cases does it ever become necessary to have that. But it's a good insurance policy, and people like to have insurance.
So on paragraph 2, Skyler, on paragraph 2 on page 2, where it says the firm will, it says the firm will consult with the county attorney prior to representing the client or its officers in any filings. So I want to stop right there for a minute. And I understand maybe the bottom sentence where it says the firm will also copy the county attorney on any communication between the firm and the client or its officers. So let's set that aside for a moment. Where I'm at is, and again, I know you guys have tried to clarify it for me, and sometimes you have better luck with a brick wall, but where it says the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or any activities in federal, state, or local courts. And so what you're saying is, or what this is saying is, as I read it, in layman's terms, is, hey, if it goes to that, then we just want all the information.
Sure, and I completely understand that. I don't think that that paragraph was necessary just in the first place because my representation agreement doesn't cover if it goes to that. I'm only here for the investigation and the pre-discipline process, which the sheriff is going to be the, the custodian of the records anyway. He's going to have his own decision and all that stuff. I mean, that's already going to be on the county's servers and things like that. My issue with that, it's a kind of a technical issue. Most of that paragraph or that sentence that you read really just concerns the courts. So where my technical issue is on hearing proceedings and activities. And the reason why is because the Loudermill hearing is a hearing under the case law. And if you look at the PCAP's Bill of Rights, the statute, it specifically uses the word proceedings, hearings, and I've addressed this to the county attorney in email. That language is a little bit too broad. If it just even ended at the first if it ended at local courts, period, I don't think that that's as much of an issue. The copied on all filings, hearings, again, that's not going to come up because that's outside the scope. I'm not filing anything, but there could be a pre-discipline hearing, and then the word activities, that's very broad. So that's where, if we got rid of that one part of that sentence, I mean, I don't have any problem with it because my agreement doesn't cover litigation or appeals, but it does cover pre-discipline hearings.
So what you're saying is that if it stopped at state or local courts,
I have no problem with it then.
so let me ask you another question or come at it from a different direction. I'm not trying to be problematic here, and I apologize, but I like to have as much information as I can get.
Absolutely.
So in your expertise, is there a concern that this paragraph or portions of this paragraph would indicate the disclosure of information that may cause us a problem down the road prior to any potential additional hearing or litigation or whatever?
Yes, and here's why. I don't want to get into all of the case law. I'll just tell you that the statute, like any statute's not perfect. I mean, it goes through the legislative process and how they make the sausage, but it's not a perfect law. So if hypothetically an employee wants to come back and they want to file a lawsuit, they do not, under this 80F chapter, they do not sue the county. They sue the sheriff, the chief of police, the lieutenant, the sergeant, whoever that they believe violated their rights. And arguably, they could sue the county attorney, although there's been some legal dispute about that, because I believe that they could, on the confidentiality provision, sue the county attorney. Other provisions in there, they can't, but I believe that on the confidentiality provision, I believe that they could. So the whole purpose of what I'm saying about that is let's not go down that road and get into an issue, because at least one of the employees has an attorney. And when you know that somebody else has an attorney, and this person is a very good attorney, we don't want, and I would never want to put the county or any of its officials in a position where somebody could have an argument to make against them. And so by doing that, in my mind, it's mitigating the risk. That's my point with that. I don't want to even open up the issue. That's where I'm coming from. Because frankly, these are 2-3 years of litigation. It just seems nonsensical to open up that issue for something that, as the county attorney indicated, this isn't, a super controversial officer involved shooting, or, this isn't, something. The facts are going to be the facts. They're straightforward, but you don't want to get into a situation where you violate somebody's rights and otherwise you do everything right, and then it comes back because, we didn't follow this piece of that law, and it could invalidate the whole thing. Like, I don't want that to happen. That's where I'm coming from.
So would our human resources personnel be kept apprised of certain aspects of it without?
Sure, absolutely. So, for example, it's public record right now. If a public employee gets terminated, it's a public record that that person was terminated and the reasons for their termination, right? That's in 22.15. And so, and they have to be provided that notice ahead of time. So if that person, would be terminated, that would have to be disclosed. Or if, for example, there would be a day off, obviously there's information that would have to be disclosed. I'm just speaking about the limited information that's covered by that statute, the complaint, the officer statements, things like that. It's not that the county is going to be completely out of the loop. It's not that HR or the county attorney. I'm just saying that limited subsection on that piece.
So if we were to strike everything after local courts, you would be okay with that?
Absolutely. And I would get this thing moving forward. As the county attorney indicated, there is a timeliness to these. I mean, they have to be completed within a reasonable period of time. And I think we could get moving, get this thing rolling, and get my portion of it done in short order.
Can I ask a question to you, Skyler? Do you think that the board can delegate to you some type of heightened level of confidentiality that does not already exist between the county attorney, the county supervisors, and the county sheriff just by nature of their positions? I think the answer is no, right?
No,
So any
I'm
concerns
not
about
arguing that.
Yeah, so any concerns about confidentiality, anything that would be imputed to you would be imputed to the attorney for the county anyway, right? As far as confidentiality goes?
Well, if you're involved in the matter, that's where the independent thing comes back in, because I do believe that they can delegate and say, on this particular matter, we're seeking independent legal representation from an outside attorney. And so that's where I said, are you in it or are you out of it? And that was where I was interpreting things and under the understanding that by having outside independent counsel, essentially, that would mean for the investigation piece and the part that's covered by ADF and the pre-discipline process, I would be handling that piece. And so that's where I was coming from on that.
So if the contract stipulated that there would be information provided through CC or copied on all communications, but no input, no direct input, would that satisfy your concerns?
I don't think so, because of that ADF 1 subsection 20. I mean, that's where my hang up is, frankly, Chauncey, is that.
But that's the confidentiality thing that we just addressed that essentially exists with you as well as my office and the supervisors.
I don't believe I don't believe that it exists with you if the county Board of Supervisors is saying we're hiring independent outside counsel for these matters. That's where I'm coming from. Because again, the sheriff could just say, I'm going to do it on my own without consulting, legal counsel from either my firm or you, and just do it. Obviously, that would not be the best scenario. I mean, I always think that whether you're an employee or the employer, you should always have legal counsel involved in everything to mitigate the risk. But that's just my 2 cents.
Yeah, I think it'd be a terrible idea if, let's say the board decided not to sign this contract, and then the sheriff decided, instead of consulting with you or my office, never mind, I'm just going to do this on my own. That'd be a terrible idea.
And that's where my concern is that we would be at, and I'm trying to thread a needle here, and again, I don't want to be involved in anything else. I've said that a million times. I'll say it again. I think this is these are 2 separate, distinct, matters that we can handle, get them done, moving forward, and be done with them. Whatever the outcome is. We haven't even got to that point, though, because we're in the investigation phase right now.
So the inserted paragraph on page 1, would that stay?
I don't have a problem with a problem with that.
Because it does say above that, the client agrees that the firm and its attorneys will exercise independent professional judgment and will provide the Jefferson County Sheriff's Office with advice and counsel without interference, and that's your language.
Yep. And that's our standard language that we put in,
Right.
any agreement like this.
And then section 2 there, the scope of services, none of that was changed. And it says attorney and firm will not be obligated to once the cap is, we know that. So, but it's pretty Says any discipline hearings or proceedings that may arise, other related discipline meetings, hearings, or proceedings. Representation includes participation in the administrative matters, review of evidence and policies. Representation will include providing advice, recommendations, guidance, and counsel through the completion of any administrative investigation and proceedings, if applicable. Representation may include other representation activities, including drafting or revising documents, correspondence, research, communicating with employees, legal counsel, and/or representatives, communicating with those involved, so on and so forth. What I'm asking categorically is that information available to us moving forward if it goes beyond the scope of the administrative review process?
Yeah.
That
So like if it goes to like a litigated or to, yeah.
is ICAP entitled to that information if they're representing us?
Yep. And to be frank with you, sometimes, and I can't speak for ICAP, but yes, that's the simple answer to that question. A lot of times what will happen is, because this happens, I mean, I've had this happen with other cities and counties. So there was another case where I handled for a sheriff's office, a deputy sheriff. I did the investigation piece with them. The deputy ultimately was terminated and appealed it to the Civil Service Commission. And the county had turned in the claim to ICAP, and they had basically assigned me just to continue on. So it was one attorney all the way through. That does happen, and that could happen here. I'm not saying that wouldn't happen, but you can have continuity of counsel too. And at that point in time, it's not an issue. The only reason why that language was in there was just to keep it very narrow in scope, so you knew what you were on the meter for with your $5,000.
But why wouldn't you want continuity of counsel with the county's attorney, I guess? I hate to keep beating the dead horse here. I'm flummoxed by the idea that we're trying to fight a legal battle and protect ourselves in the best way possible, but also tying one hand behind your back by boxing out the county's attorney's office from having the information best at fingertip in order to defend. It's wild. And when you say this hasn't been addressed before, you know what? It probably should have been addressed before, but this is not an area of well-trodden ground. It's crazy that we're even having this conversation, frankly. We're all on the same page.
Well, the paragraph that was inserted on page 1 at the bottom says nothing in this contract is intended to interfere with or impede the county attorney's obligation to his statutory duties. And then if we leave in on page 2, second paragraph, the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or any activities in any federal, state, or local court. But the contract does state clearly that this ends, it's a pre-suit poor choice of words, but a pre-suit operation, a pre-suit. So I've done a lot of questions and talking here. Joe, Susie?
Go ahead, Susie.
No, I said I'm just listening.
Oh, okay.
Oh. Well, sounds like you're moaning too. Everybody's laughing at me.
Perhaps you should get a hearing appointment.
Okay. So, I'm on that. I questioned this second paragraph at our last meeting last week, whether that needed to be there or not. So I would be happy to leave in the first part of it and cross off the rest of it, if that's what Skyler would like to see done.
So to
Cut it off after the federal, state, and local courts, and just eliminate the rest of that, because if it does go on, everybody can get a copy of stuff and be brought up to speed then. It's attorney-client privilege. So how far out are you going to go on this?
I don't know what you mean, Joe, and I'm just not sure where you're going.
On the attorney-client?
Yeah.
Well, most of that stuff is between the attorney and the client.
Which is
Who's the client, Joe?
Bart.
No,
No.
No.
that's been my,
The office of the sheriff. It's the office because it's not. That's where this is part of the issue with these code sections. It's a mess. It's not. I'm not representing Bart. I want to be very clear about that. It's the office of the sheriff, which is it's an official, right? But just the same as Chauncey. Chauncey holds the office of the county attorney. So, the representation is not of Chauncey in any individual personal capacity. If somebody was going to represent him, you're representing the office. So that's where the language becomes, in some situations, it's synonymous, right? In some situations, it's not. But for this purpose, and I'm just saying it, for this purpose, where we're talking about the investigation and we're talking about the potential pre-discipline process under these code sections, it is the office of the sheriff, or I just say sheriff's office because it's short, of Jefferson County. That's the long way of saying it.
The client's Jefferson County.
Yeah, I stand corrected. I meant the office of the sheriff, but I referred to Bart.
Yeah, because I don't want to be in any. I'm not. I know you said Bart. I just want to be very clear. I'm not representing Bart in any personal capacity. This is not in any way, me representing Bart in anything, involving Chauncey or adversarial with Chauncey. So I just want to have that on the record because that's not the intent of any of this.
Okay, I stand corrected. I'm sorry.
So any other questions or concerns or Bart?
Can the county, through the county attorney's office, get access to all of your information in the future, including matters that you handle up to the time while you're doing your independent investigation while it's going on? I know you save those and store those within your law firm and trust your other lawyers in your law firm not to violate confidentiality. But can the county attorney, what is your understanding of when the county attorney would have access to that material?
So I think that if that, for example, if it goes bound to an appeal, litigation, anything like that, no issues with getting, for example, I'll give you a general example here. So if somebody's going to be disciplined, there's a notice that's provided to them. Usually it's titled like notice of pre-disciplinary hearing, and it tells them on this date, this time, a pre-discipline hearing, is scheduled. This is what the allegations were. This is some of the findings. Basically, it's a summary, and that goes to the employee. That stuff, that unless it includes their statements, which generally the summaries do not, but that is not an issue at all. Now, let's say that I write a letter to the sheriff and I say, here are options, or, here's my advice or recommendations, which would be my work product. At some point in time, let's just say that there's third-party litigation or whatever, that would absolutely be something that could become available, if that would occur.
Does the county attorney have access to it prior to litigation? That's my question.
And if there's
available, just as it is available to other people in your law firm, say you were not around and we needed to find out what had happened. If a claim is made of impropriety by one of the people without litigation being filed, but of one of the people that might have been involved in this, how does the county get that? And do we have full access to that? Or do you just give access to that to people that are in the office of the sheriff?
So you're saying there's two parts of that. If the simple answer to that question is if there's an appeal or if there's litigation, that's something that could be out there, right? That could go to the county attorney.
How about pre-litigation?
Pre-litigation, like no claim, no demand, nothing like that, then I would say no, because it's in the investigation phase or the pre-discipline phase. at that point. But if it was after that point and there's an appeal, or if there's a legal demand that's made, because sometimes people send demands before they file suits, or whatever, that I think would be the triggering thing. We're just talking about confidentiality, and that process during the investigation and during the pre-discipline hearings, unless there was something else that happened. So
What is the harm for me as the attorney for the county if I'm going to be possibly handling future matters in this? What is the harm of me seeing the process and following it from afar, viewing your emails and work process?
So again, it goes back to the confidentiality piece. These peace officers have unique statutes that are protecting them, and it's basically like a need to know. If the county attorney doesn't have any involvement in the process because the board has hired independent legal counsel, then there would be no need for the county attorney to have that information. The need would arise if there's an appeal, there's litigation, something like that, a triggering thing. For example, if the county attorney just wanted to know what happened with these employees, that's one thing. If the county attorney wanted to have, wanted to know what the statements were during the interviews, that would be a different scenario, because what's the need? The county attorney is not representing the county in anything because there's nothing pending. The whole point is
providing this information. Excuse me, I'm sorry to interrupt, but would you be providing this information that's confidential to the sheriff during your investigation?
Well, no, I would already have it, because that information would be something that happened and the sheriff would already have it. So that's the stuff that John Thomas is doing. So for example, there's an interview of an employee that's conducted, I could get into the weeds all day with you, but I think in certain situations, to answer the question in the shortest, most succinct way, in certain situations, the county attorney gets access. In certain situations, it doesn't. I think if you look at it from a perspective, if all this gets resolved and there's nothing that comes out of it, the short answer is no. If something comes about of it, then it's maybe. If it's litigation, I think that's a lot easier of a question. There's a gray area there in the middle, and I can't tell you exactly what's going to happen, or again, it's a mess, and it's these are open questions. We could go hypothetical all day. I've tried to cover the things that are the most possible based on my experience, and to try to mitigate risk to the county, to the sheriff's office, to all involved, to everybody. From my perspective, it's just one perspective. There could be disagreement with that, and that's fine. People can agree to disagree, but without having, some case law or some guidance, I just don't want to end up in that position. I do not feel comfortable with that. That's the bottom line of where I'm coming from. And that's just my preference. And knowing what I know about these cases and how they work, I just don't feel comfortable with that. So that's why I'm asking for that change.
But you are going to provide that to the sheriff's office during the investigation or during your service as counsel?
No, I don't. The investigator provides that.
Okay. What will you be providing during your time of being counsel?
I don't know the answer to that question because I haven't seen anything yet. I have no videos. I've gotten a couple reports, and that's it. I have not had anything because I haven't done any work on this other than appearing for the 2 interviews that were scheduled because I didn't have a choice.
When you do find a result, are you going to make that available during the process?
I think that the result, that question is not mine to determine. That's the sheriff's, because I'm not the one with the statutory authority. The sheriff is. Again, if it's a termination, that's a public record. So absolutely that becomes available. If the sheriff decides to do anything other than termination and the employees don't appeal it or challenge it, then that stays confidential. So I can't answer all the hypotheticals of how all that stuff would come up. I just can't. I mean, we could literally be here for 2 hours longer talking about that. I'm sorry, I can't.
I appreciate your skill and everything, but I worry about the other possibilities. I've been involved in police shootings myself as a prosecutor, and wished I had known more of what happened on the way in.
Oh,
Thank you, sir.
I agree. I agree. When you said you've been involved in police shootings, I assumed it was as a prosecutor.
That is correct.
Okay, so Skyler's right and Chauncey's right. Well, beat a dead horse. Horse is still dead. So at least, I don't know, maybe you can beat him back. I have no idea. Never beat a dead horse, so I don't have a clue. But anyway, but all right, so we're okay with page one, the inserted paragraph. Page two, they have concerns if it stops at local courts and strikes the last three sentences, they're okay with that.
So you need a motion to do it, or we just do it?
Well, no, I think we need a motion, and then, and in that motion, I think if it's approved, then you authorize the chair to strike that and sign the contract.
What are you chasing? Fly?
Yeah. Or moth, I don't know.
So, well, we've been at this for an hour. It's time to move on. So I move on the second paragraph to leave in the first sentence, the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or any activities in any federal, state, or local courts. Strike the rest of that.
And leave the inserted paragraph in.
On the first page, yes, leave that inserted paragraph. And authorize the chair to sign if it passes.
Susie, you have any thoughts? Did you go there?
She fell asleep.
Did you mute her?
No,
Okay,
she's still there.
okay. Evidently not.
Susie, yes,
No, I'm here. Geez, I've been talking to you. I'm sorry.
No.
I didn't know I was.
Oh,
Anyway,
we weren't hearing you, so I'm sorry.
what was the best conversation we've had?
Oh,
So did you hear Joe's motion?
I did.
Okay,
okay.
just wondered if you had any comments on it, any thought process?
You know, as you realize, I always want the best. Can you hear me?
Yes, yes.
I always want the best for the county, and I'm always concerned about the money we waste. So I'm just listening. Thank you.
Okay, so we have a motion. I'll second the motion. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Opposed, same sign. Motion passed. I have a copy of this on the computer. I can strike that last section and sign it if you want to wait. And then give you want two signed copies?
Yes, please.
Okay.
I appreciate that, and thank you all for your diligence and your time. I know that these things are not always as easy, especially with things that don't come up, and then you start talking with attorneys, and we start talking about legal things, and it just goes downhill from there because we're attorneys. So I appreciate that. If somebody could email me the signed version when it's done, I'll get to work on this and we'll get moving forward. So thank you very much for your time today and paying attention and your good questions, all great questions too.
Well, I appreciate you and the opportunity to have the conversation. So I'll get this taken care of. I want to let everybody know online that in a second here, we will adjourn. There is a meeting at 1 o'clock, but it is a closed session. So it will not be on Zoom. What?
You have to start an open session.
Well, okay, but I'm not gonna fire up Zoom, I don't think. I mean, I guess we can, and then unfire it.
Keep him in line, Abby.
Just,
I believe our brief is going to happen on Zoom.
the attorney will be on Zoom.
Oh, good. No.
He will be here in person.
Oh, he will be here in
He's
person.
already in town.
Okay.
Okay.
All right. Did you catch that, Chauncey?
Yeah, I got it.
Okay. Thank you.
Thank you all. You have a great afternoon.
Thank you,
Yeah.
Skyler.
Thank you.
Tyler.
Motion to adjourn.
Dave?
Yes.
I will be calling in for that meeting.
Okay. Yep.
Good enough.
Same time,
Thank you
same.
to everybody.
Yep. Same time, same back channel.
Thanks, Susie.
I had the restroom.
Okay.
I seconded your motion.
All right. All those in favor say aye.
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 It appears that folks are in agreement as much as they can be, and the contract is now going to be signed by Lee Dimmitt with the Jefferson County Board of Supervisors. Interesting thing to watch, isn't it? Thank you. If you're still here at the end of this and you're actually seeing this part of it, thank you for that. And make sure to give this episode a like and make sure to follow and subscribe. It is free. I need to thank my sponsors, Griner Auto Body, Car Doctor, McDonald Boneyard, Your Choice Family Restaurant, Girling Repair, B&B Propane, and the family of Jet Stops, CW Tree Trimming, LLC, Dutch Market, and Coffee Talk. I'm your host, John Bain. Stay friendly, Southeast Iowa.